TAT/IB/063/2022. Sorry. TAT/IB/073/2023. United Bank for Africa versus Ondo State Board of Internal Revenue. Past President. No appearances.
May it please this Honorable Tribunal, my name is Samuel Isuga. I appear for the appellant. Appearing with me, Mr. Chairman, members of the Tribunal, are my colleagues Ijeoma Onya and Chidinma Chukwudi for the appellant. Yes, Mr. Chairman, Samuel Isuga.
ESUGA.
ESUGA. A. Yes, Mr. Chairman. Appearing with me, Mr. Chairman, is Ijeoma Onya. And Chidinma Chukwudi.
Chukwudi.
Yes, Mr. Chairman.
May it please Honorable Tribunal, Aisha Musa. For the respondents.
What's the position?
Revenue Supervisor. Ondo State Internal Revenue Service. Yes, sir. Yes, sir. Appearing with me is Precious Aliu.
Precious Aliu.
Yes, sir. Our humble appearance is for the respondents.
What's our position? What's our position?
Yes, she's serving with us. She's a copper.
Okay, so what is okay? The floor is open for.
We can't hear you anymore, sir. The line is.
Your addresses are going to cancel. Just like that,
Mr. Chairman, we are losing you a bit. Mr. Chairman, I don't know if you can hear us.
Can you hear me now?
Yes, we can hear you now.
I said, I would have hear me now. Okay. We had you when you spoke. Can you hear us now? Can you hear me?
Mr. Chairman, I can hear you.
I can hear you, but it's not there.
Okay, I said the floor is open.
Most grateful, Mr. Chairman. Mr. Chairman, members of the tribunal, the appellant filed its final written address. Or Mr. Chairman, maybe subject to your guidance, maybe the respondent will, I don't know if the respondent will adopt first before us. Sorry, Mr. Chairman, I didn't hear you.
Respondent,
As
Sir.
Tribunal, please.
adopt your address.
Okay, Mr. Chairman, sir. Honorable Tribunal, we have a final written address filed and dated 23rd of February, 2026.
File where?
23rd of February, dated and filed 23rd of February.
What we can see here is 30th of December 2025. We file everything after that.
I'm sorry, I didn't get that, sir.
Your address that we have here is dated 30th December 2025. Did you find anything after that?
Okay, to my knowledge, it was just sent in yesterday, sir. Apologies for that. See, there's no date.
Beg your pardon?
Mr. Chairman, I'm not
I
aware
didn't
of
get that,
this
sir.
process.
Can you repeat yourself? Will you repeat yourself? Counsel to the respondent.
Sir, I didn't hear what you said, sir.
I told you that your address that we have on record is dated 30th December 2025. But you made reference to 2026.
Everybody's frozen. Okay, sir. Apologies. Correction taken.
No, which address you want to adopt to understand? Because we don't have anything dated 2026 before us.
Apologies, sir. I was just given this brief this morning and it was sent in yesterday. So I assumed it was filed and sent in yesterday.
Can you look at the hard copy of your address? Can you look at the hard copy of your address?
Can't hear anything.
Can you look at the hard copy of your address and talk to it to us?
I don't have the file in front of me. I was just told to adopt this final written address this morning by Adebayo Ogunseyi.
Okay. Looks like you are not ready. Okay.
Sir?
You are not ready to proceed with your case. That's what it is. You are not ready to proceed.
It would appear so, sir.
All right. You will start down your case. I thought we will expedite the proceedings concerning your case before we go to hearing. But now we'll step down your case to its.
Okay, sir. Thank you, sir. As the tribunal pleases.
This for today. So when we are done, then come back and address us properly. Okay? All right. So the case is put down accordingly. Listen. /IP/063/2022, Federal Inland Revenue Service, versus Ogun State Government. Accountant General Ogun State and Accountant General of Constitution. Past President. Go back. Past President. Mrs. Obiali.
Yes, please. Good morning. Good morning, Honorable. My name is Oduyale Taiwo Fumilola, representing Nigerian Revenue Service. Deputy Manager Tax. And with me is me.
Appearances. And then all of them. She's representing FRS as a tax. Not as an answer. Okay, she mentioned that someone with that.
Yes, Mr. Chairman, she mentioned that she wasn't clear. She wasn't clear.
Who is with you?
Ofumi Akinbode, Officer 2. Akinbode, Officer 2 Tax.
Appearances.
With profound respect to this honorable tribunal, I, T. Abdul Rafi, my humble appearance is for the appearance. The honors with me, F.A. Chalet, and F.O. Sabao. The honors with well.
TF, what? Chief State Counsel of State Ministry of Justice, I appear for the first and second seconds. Yes, sir.
Chief State Counsel.
Yes, sir. I've been I couldn't rest in my name. My humble appearances for the top responsibility.
I've been one Aki.
Aki Press is spelled AKI double NIFESR. With top responsibility. Must family advisor.
Okay.
Chairman, matter is stated for here today. And so just to our past, we are available. For the further, Mr. Chairman, we have a pending application for the sort of tribunal, which of I know that is the hearing of this appeal. Is that no possible to substitute witness? It is dated the 26th day of January 2026. We move the last of the all the council of the first and second vice president was absent.
So what should we consider?
The 26th, we of January 2026. And filed the same.
And that's for me to something this time. For we must start with that, yes.
Very well, Mr. Chairman. Well, I wouldn't know the stats, if they are not supposed
Are
to.
you objecting to?
Why would I object?
The objective. Alright, so move the motion. Sorry, you didn't finally capture the deputy.
We were just solved today. In court.
So that's it for your objection.
That was one of the reasons.
Why we don't miss out on this? The motion was filed in September. Let's say it's short. Hold on, so,
We something.
Somebody wanted to hold difference.
I think
I said
we
so.
can copy rather. We scan and send via WhatsApp
to who?
to council.
Yes, I think
And I said that on the last.
what number did you send it?
That should be on record.
What number did you send it to? Well, I'm sure you have a correct number. What number did you send it to?
Mr. Chairman, I just want to kind of guide the honorable chairman. I will recall that last time, council did mention that she will just scan call. I wouldn't know if that's actually contained in the record of the proceeding of the tribunal.
I'm thinking about processing, but how for the motion, I said in the last 6 years.
Okay, I think that's this first. So I think that's sorry, Shannon. So that's what we recorded. So even though we have the because of institution rights, we are aware of these applications as of last time. And said that objection. So we did rule on this. In order to be the first and second respondents, the opportunity to come and react to the application, whether you want to oppose or not. You have to speak like that.
Matter can proceed.
As long as whether the matter can proceed.
Yeah, if you're after for more position to this application, they have really council. How many local council position architects all this one drive grants are already
Then another 20 people that it's about the minimum of this value. It's 5 of it is still now. If you have something to do with that, this is business is 5.
Yes, no, that's the question.
And then you invest in money to 5. You need to 5 is invested
To 5 our investment.
Yeah,
The current ETS we have at ground is for this application law is Mr. Ibrahim. And we explain the reason why because yes, they are not successful. Yes,
it's how you phrase your prayer. Is you actually substituting Mrs. Taiwo and for Mr. Ibrahim.
I shall not restore. I shall not restore.
And
We are ready.
you have to amend condition.
Don't know, I don't think, thinking, I'm going to go our the first prayer on mentioned. Another glancing the appellant substitutes this style would be like it's something we start that will with this inside, for inside doing now. I'm not going to go.
Any objection?
No objection. No objection.
That's just the child there.
Yes, I tried it 20th of February. What's the new update of the Tribunal? They need for us to amend our procedure.
We'll get to the. The applicant's initiated from this directed from six. The motion was granted as approved. According to instructed by the tribunal. So the applicant substitutes Mrs. Tyree Galvin as witness for Mr. Akeju and his witness statement on both. And the legal file the self-determination as having in properly filed inside. Shall not absolutely shall not be. Person. That's the idea. Not to speak louder, so that
On Friday, the 20th of February, the director of the Tribunal counted the chance to that they followed up on the minister's office on an audit with the same thing. And this was a document in the docs. As presented in the organization and the petition of the Fiscal Commission. Their letter dated September 1st, 2025. Going to the honorable is directly accountant general, big assembly of about 67 billion, 461 million, 760,451 naira, 85 million. As at yesterday, we are still at this happening of this time. Let's have it. That's what is about to. If applicant it's an agency of the police, just as it was. And we've had very good cordial relationship with the fulfillment of our mandates. We are surprised that despite this resolution, and they were representing the National Committee, we are still in touch. We reached out to the SAT of the chairman, to the chief of staff, and he said he's surprised that we are still in touch. That after that resolution, FRS has stopped the hospitals paying the outcome. So we are shocked that we are still being trapped by FRS. And based on other 40, we won't be on this spot, very tribunal. They expected that by now, they would have found a notice of inspection. And at the resolution, the report, they were represented there. 3 of their staff were represented. So the honorable minister of finance did approved for the said deduction. And they also have the binding to instruct their accountant general to make the said payment. They are not even a country. And we all work together.
So the minister has already directed.
Well, flat, this is
Yes, after work.
has directed
Yes.
the honorable minister to make an approval for the sum of 67.something, which includes that 1.2.
Yes.
As at yesterday, Director of Financial Account, the update, as at yesterday, 5 k, no for finance. The letter has gone, minister has not sent out, it hasn't even come out. So that means that headquarters are going to
as happened, I think.
they don't be targeted.
So the matter is on its own.
Well, based on the resolution, it says for now they should suspend all action. And this effort will be.
Well, you know what it is.
And FRS was there, they represented the site to the resolution. Meaning that they were okay with it.
The tribunal will serve or and operate on the basis of parties' consensual decisions. Okay, everything we are saying now is evidence, it's not false.
That's why we vote for our best and we attach it. Just got
Try to that and put that before.
you just got it on Friday.
Yes, we took Friday and one go to our Friday.
We apologize to the check on the chance.
And I believe they are not okay. So we keep on looking for money, just because.
No, we didn't go all this, and for just yesterday, my friend like showed to me, when I said, at about 5 p.m., that we got this other information from all the registrars.
We're saying it's not bad. Because everything we said, it's not bad, but what that says.
That's why we started to look at it.
Okay. So what do you want to amend?
Once you have made our turn was myself, and I don't. You fact.
What to amend? So the question of intention, they're not the before, good parts of that is.
If not, father understanding for them.
I understand. See, what the father amended, there's no most of the time. Yes, is it in front of us?
Okay, don't go to
All right. Let's start with this.
Yes, I just want to be sure that if it's a different document, my element committee prior to that meeting. Because they are part of the documents.
So that is not. But what's you want to remind somebody?
Very well. Yes, so. So, if those documents is the internal memo for the and details of the signature. I just wanted to show if same document are the next to that. We don't give away on the internal document. Yes,
No. It's our question. Not before the.
Is there any other friendly motion to follow the Tribunal?
no, no.
What's our second? Is that any?
No.
Correspondent, we are anybody now. For, so now, we are, what's that, what you supposed to do?
On my part, I'm pretty very good. However, I have the directive from the office. It's coming to the office. The director should come and do the trials. I'm going to do it to do this. Should director know that it's the trial. But the director said she wants to do the trial personal affairs.
What's it directed?
It's no problem for the patient. That's the director of the patient is speaking. What I'm going to do. Public presentation. This is big. What I know, I think what I mean. That's what people need to do, what sense of matter, but what's the stop it to be nice. It's not complicated. First of all,
Because.
or any other.
About the photo.
No.
Well, we are just. I can look for you. This. You know, we.
Absolutely, you have to go of the minutes of so that's the thing, actually goes all these ones. So of course, we need to do sales make of noise for all of this. And that's why we need to have looking for the it's not just for people for fear.
So it's exactly this. Are you attending class?
So much.
Every day of class.
So outside is from what we do.
Where you are, let me buy. What happened?
Right.
You want that, that. I mean,
That's why the money we that makes like not people so that's the difference. That was just reading. So after section I
so it is so.
first it's one of the most beautiful.
That person for the applicant and respondents. Further, this is like, what is the?
Not like another place. Need to.
Not the first for 10 weeks, and I'll come up with 6. So I like how it's always.
But CAT/IB/07/3. United Bank for Africa versus United States Board of Internal Revenue. Past president. No part. Appearances.
Mr. Chairman, sir, apologies. Same appearance for the appellant, Samuel Isuga, with Ijomonia and Chidima Chukudi. For the appellant.
Mr. Chairman, sir. My name is Adebayo Ogushui.
Mr. Bayo, we can't hear you.
My name is Adebayo Ogushui. Adebayo Ogushui. Mr. Chairman, sir. My name is Adebayo Ogushui. And with me is my colleague, Precious Aliu, for the respondent. Director, yes, sir. Director Legal. And appearing with me is my colleague, Precious Aliu.
Is it with Y or without Y?
Yes, SUYI.
Is Aliyu with
Precious
Y?
Aliu. Precious
Spell Aliyu
ALIU.
for
ALIU. ALIU without the Y.
All right, thank you. Now we have to see your face well. What we are saying is a dark image. Okay, so I think you have to block the light in your background. You have to close your curtain.
The light is on, sir.
Yeah, close the light. Close the blind, close your blind, close your window blind, the window blind.
Okay, window blind.
Yes. So that there's no light reflection.
Yeah.
But it also seems to have made a difference. Yeah, can you back the window? Can you face back? Yeah, can you face the window? Can you sit on the opposite side of the desk? Yeah, because you need to see your face well. Yes, yes, it's another part of and then side of the group. This is better. So let's just see, yes, other side, exactly. Exactly. Okay, you can carry on. You can carry on now.
Okay, sir. The matter is for adoption of.
Are you raising the volume of your device? Volume.
Okay, volume.
Volume.
No, it's the highest volume now, sir.
Okay.
Increase the volume.
All right. Just on the position that is step down. I record your address or speech. Okay, adopt your written address.
Okay, sir. Our final written address is dated 29th December 2025. 29th December 2025.
Yes.
And filed on 30th December 2025.
Yes. Yes.
And we seek to adopt, sir. We seek to adopt as our defense for the substantive appeal. And also for the cross appeal, sir. We filed a cross appeal.
Okay.
So we urge the tribunal to dismiss the appeal, sir. We urge this tribunal to dismiss the appeal. And award the cross appeal. Thank you, sir.
Mr. Chairman, sir, members of this honorable tribunal, the appellant filed its final written address on the 19th of January 2026. It's dated 19th January 2026 and filed on the same day. Yes, Mr. Chairman, this contains the appellant's argument in support of its notice of appeal and its argument in opposition or response to the respondent's final written address. And we wish to adopt this as our argument in asking this Honorable Tribunal to grant all the reliefs sought in our notice of appeal. Mr. Chairman, I don't know if the Tribunal can indulge me for no more than 3 minutes. I would just like to adumbrate for no more than 3 minutes.
Says, the grant all the reliefs sought in the appeal. So grant
Sorry, Mr.
all the
Chairman.
reliefs sought.
As Tribunal President, yes, Mr. Chairman, to grant all the relief sought in our notice of appeal.
Was it addressed the first appeal? Or the third appeal or whatever?
Sorry, Mr. Chairman, I didn't quite hear you.
Is there any relief sought against the first appeal of matter plate in your address?
No, Mr. Chairman, our notice, our address, the notice of appeal, we believe is sufficient to deal with the issues before the tribunal. Because we are asking for the assessment to be discharged, which is what the cross appeal or counterclaim is based on.
So, what if I say something? Can you go on?
Yes, Mr. Chairman, I was just asking for your permission to just adumbrate for no more than 2 to 3 minutes.
Yeah, we'll come to that because this is one of you to walk us through. What you have written there.
Sorry, Mr. Chairman, can you please take that again?
We will come to that because we want for each of you to walk us through your address.
As the tribunal pleases.
And then emphasize everything you want to emphasize your light at that point in time.
As the tribunal pleases.
Let's address the addresses. Okay?
As the tribunal pleases.
The respondents to the appellant's written addresses. Finality addresses. Hereby respectively admitted by the tribunal as adopted by both counsel.
As the tribunal pleases.
Tribunal pleases.
So now we want to hear each of you. So what are the various submissions? Well, let's start with the question.
Thank you, Mr. Chairman, sir. Thank you, Mr. Chairman, sir. We identified 2 issues for determination. We identified 2 issues for determination, sir. The
Yes.
first issue is the issue of jurisdiction. That the tribunal has no jurisdiction to entertain this appeal. Because on the ground that they didn't serve us any pre-action notice. The appellant did not serve the respondent any pre-action notice. In compliance with the Ondo State Revenue Administration Law 2019 that creates the respondent.
Okay.
That's section 86 sir.
Okay, question to you, Mr. Anushki. Why did you not object to the decision of the tribunal 4 months to hearing?
Pre-action notice.
Why did you not object to the decision of the tribunal before we went
At the
to
initial
hearing?
stage, sir, and we actually informed the court, the tribunal, that will be raising an objection and that we put it in our final address. Because by law, issue of jurisdiction can be raised at any stage, sir.
Okay, no problem, that's fine. So, bring the provision for us.
The provision in section,
And they are also going to amend the tribunal of that legislation. We need a copy of that legislation.
okay, I will send the soft copy, sir. I will send the soft copy.
And make sure you copy your colleague,
I will send the soft copy.
both to the tribunal and to your colleague.
Then the second issue, sir,
I said,
is the
okay,
issue.
I want you to get me. When you are sending a copy of the law to us, make sure you send it to your colleague.
Okay, sir. Okay, sir. All right, sir. The second issue that we identified is that the appellant has not proved its case, sir.
Okay.
The appellant has not proved its case.
Okay.
And the onus, because by law, by decided authorities, which we have cited in our final address, the onus is on the appellant to show how the withholding tax was excessive, sir, and which they didn't show in this appeal. So we have addressed all these points in our final written address.
Okay.
And I know that the tribunal will still look at them, sir.
Okay. I think that provision for us, the provision of the section 83, 86 of the Ondo State Revenue Administration for 2018, give the provision for us.
I will send this soft copy, sir. After the proceedings, I will forward the soft copy.
We are saying, read the provision for us. Leave it now.
Okay. I don't have the law here presently, but it says that the revenue service shall be served 1 month pre-action notice, sir. 1 month pre-action notice. And the pre-action notice must contain the course of action and the intended relief.
Okay. Taking that.
Okay. And the Supreme Court, sir, there are so many decided cases on this point, sir. so many decided cases that says that once the service of pre-action notice is mandatory, non-service will cease the court of jurisdiction. That where service of pre-action notice is mandatory by law, non-compliance will cease the court of jurisdiction. There are decided cases on that, sir. And we cited Mobi Producing versus SEPA. The full citation is in our final decision address. So I want to refer the tribunal to paragraph 3.0, paragraph 3.0 to 3.5 of our final written address. Paragraph 3.0 up to paragraph 3.5 of our final written address. And the second, our second leg, sir, is whether the appellant has proved his case. And this is as contained in paragraph 4.0 to 4.11, paragraph 4.0 to 4.11 of our address. All the exhibits they tendered, sir. The exhibits that they tendered did not in any way relate to the list of POS agents that they gave us, that is before this court. I said the exhibits tendered by the appellant, sir.
Yes.
That they say they have paid withholding tax, and they now tendered exhibit, sir. And I said that exhibit does not in any way relate to the POS agents operating in those states.
You don't relate to what operation of those states.
It just they do not relate to the list of POS agents operating in those states. They gave us a list of POS agents operating in those states. And the exhibit they tendered that they have paid did not in any way relate to the operation of all these POS agents.
Okay.
That's exhibits UBA 7 to 10, sir. Exhibits UBA 7 to 10. Exhibits UBA 7 to 10.
Yes. Yes.
I also want to refer the tribunal, sir, to exhibits ODRS 1 that we tendered. Exhibits ODRS 1 that the respondent tendered, sir.
Yes.
Where the bank, the appellant, wrote to CBN that they want to leverage on their growing agent network. The appellant made an application to the CBN for approval. So inside that letter to CBN, they said they want to leverage on their growing network, on their growing of agent networks. So it means that by implication, they have been doing POS agency even before the approval came, sir.
Okay.
Okay, sir. And then thirdly, sir, there is nothing before this tribunal to show the commission earned by these agents and the withholding tax the commission earned by these agents. And the withholding tax deducted from the commission. There is nothing before this tribunal. Okay, sir. And they also said they have 267 POS agents in Ondo State. They say some are active, some are not active. There is nothing before this tribunal to show which agents are active and which agents are not active. Okay, sir. Then lastly, sir, on our counter claim, that's the cross appeal. Paragraph 5.0 of our final address, sir. 5.0 of our final address. The appellant, sir, that's a cross respondent now. They didn't find anything in answer to our cross appeal, sir. They didn't find anything in answer to our cross appeal. They didn't find any reply to our cross appeal, And in law, sir, they are deemed to have admitted our cross appeal. That's what the law says.
Yes, sir.
This tribunal should dismiss the appeal, sir, and award our cross appeal. Yes, sir. Yes, sir. Thank you, sir.
Yes. Okay. You're done.
I'm done, sir. I'm done.
Appellant.
Thank you, Mr. Chairman. Mr. Chairman, we will just go about this very briefly. In our written address, we have put it into segments where we responded to the respondents' address and arguments. We have also identified some issues that we consider as preliminary issues. And then we have also identified 2 issues for determination, Mr. Chairman. Basically, the 2 issues for determination from our end is whether this, what's the...
On what page of your
Mr. Chairman, the issues for determination is paragraph 48, that is page 5 of our final written address. Paragraph 48, page 5. So, Mr. Chairman, just for ease of reference, from page 5 of our final written address, all the way to page 16, we address the 2 issues for determination there, which is whether the best of judgment assessment is arbitrary, unjustified, and inconsistent with the provision of applicable law and ought to be set aside. That's issue 1. Issue 2, whether the appellant is liable for penalty and interest, having objected to the tax assessment within the time limited by law. We have argued these issues from page 5 to page 16 of our final written address. Mr. Chairman, we have specifically responded to the respondent's final written address. That is the issues, the particular issues that the respondent has raised bordering on the jurisdiction of this honorable tribunal, and the issue regarding whether or not we have proven our case. We have argued all this from pages 16 all the way, Mr. Chairman, to page 21 of our final written address. We have addressed all these issues there.
Okay, Council, can you make reference to the paragraphs? Because your paragraph is not completed. So can you make reference to the paragraphs? Just as referred to.
Oh, yes, Mr. Chairman, apologies. I think the copy I have has pages, but apologies. I'm sorry, I'm just realizing that now. Okay, Mr. Chairman, our issues for determination is in paragraph 48 of our written address, paragraph 48. And we deal with these issues between paragraph 48 all the way to paragraph 83. So paragraph 48 to 83 of our final written address, Mr. Chairman, it addresses the 2 issues for determination that we have raised, which is whether the respondent's BOJ can stand, and then whether interest and penalty can apply from paragraph 48 to paragraph 83. Regarding specific responses to the respondent's final written address, that can be found in paragraph 84 of our final written address, all the way to paragraph 118. Specific responses are in paragraph 84 to paragraph 118, Mr. Chairman. Mr. Chairman, we have also, we have also stated in our written address certain preliminary issues that we feel this tribunal needs to look at. This can be seen in paragraph 28, preliminary issues, paragraph 28 of our final written address, all the way to paragraph 47. Paragraph 28 to paragraph 47. Most grateful, Mr. Chairman. Mr. Chairman, just a few issues I will touch on, part of our response to the respondent and then part of our own argument in support of our appeal. On the issue of jurisdiction, we've made this argument in our written address, but on the issue of jurisdiction, it's interesting because this tribunal has ruled on that provision of the Ondo State revenue law that my learned colleague is referring to. In this matter, in a matter with this same appellant, this same tribunal has ruled. This preliminary objection has been brought before this tribunal, and this tribunal has ruled. And Mr. Chairman, we have the certified true copy of this ruling, and we'll share it with my colleague and with the tribunal after this sitting. What is clear, and we've repeated the same arguments. What is clear? Sorry, Mr. Chairman.
What date was it?
Okay, Mr. Chairman, the ruling is dated 21st day of February, 2024. 21st day of February, 2024. We have the certified 21st, 21 February, 2024. Yes, Mr. Chairman. And the tribunal it's a 14-page ruling where the tribunal in detail addressed all the issues that my learned friend, the respondent, has raised. And we rely on that ruling of this tribunal. Just to add that we have followed, the appellant has followed the provisions which at the time was operational of the Federal Inland Revenue Establishment Act in bringing an appeal before this tribunal. The Federal Inland Revenue Establishment Act has a supremacy provision over every other taxing legislation as identified by this act. The personal income tax provisions that the respondent seeks to administer, Mr. Chairman, is part of these laws, is a federal law which the Federal Inland Establishment Act's provision has a supremacy provision over. And we've made this argument. Yes, Mr. Chairman. Just a second, Mr. Chairman. I didn't have it written out here, but I'll just go with it now. Mr. Chairman, is section 68, sub 1 and 2 of the FRS Establishment Act. It's contained in paragraph 103 of our final written address. Section 68, 1 and 2. It's in paragraph 103 of our final written address. Yes, so Mr. Chairman, that's our argument that the appellant has complied with the provisions of the Personal Income Tax Act, which is what the respondent is administering, and the provisions of the Federal Inland Revenue Establishment Act that has a supremacy provision over all these other taxing legislation. We've complied with it. As such, we are not in breach of any applicable law as far as bringing this matter before the tribunal, and as far as the jurisdiction of this honorable tribunal is concerned. We've referred to the relevant authorities in our written address. It's interesting because the Supreme Court in a similar matter involving Osun State also dealt with this issue, and we've referred to it in our final written address. It's in paragraph 104 of our final written address. Now, Mr. Chairman, to the issue that the appellant has brought before this honorable tribunal, which is in our first issue for determination from paragraph 48 of our appellant's final written address, is whether this best of judgment assessment as issued by the respondent is valid or not. And our position, Mr. Chairman, is that the best of judgment assessment is arbitrary, is unjustifiable, and is inconsistent with applicable law. We have in our written address from paragraph 48 all the way to paragraph 83, we have highlighted, Mr. Chairman, what a best of judgment assessment is, when a best of judgment assessment can be issued. The trigger for a best of judgment assessment, as provided under law and as decided by the courts, both by the tribunal, tax appeal tribunal, by the Federal High Court, and by the superior courts. This is all contained from paragraph 48 to paragraph 83 of our final written address. What our conclusion and our position, Mr. Chairman, is that what the respondent has done did not meet any of the criteria for a best of judgment assessment. I will pick one of those criteria, which is that documents that were necessary to enable the tax authority carry out its assessment was not provided. Mr. Chairman, we have the exhibits before this Honorable Tribunal, which we have restated in our written address. This is in paragraph. This is in from paragraph 4. This is in paragraph 4 of our final written address, Mr. Chairman. We have stated paragraph 4 and paragraph 8. Paragraph 4 and 8 of our final written address. We have itemized all the documents and information that was provided to the respondent, and the time, the dates when they were provided to the respondent. Mr. Chairman, you would see when you look at these documents, they were all provided before this assessment was issued. All of them. The audit was done before the assessment was issued. All these documents. I just don't want to take too much time of the tribunal, but these documents are from February 2022, May 2022, March 2022, June 2023, and July 2023. We've stated it in paragraph 4 and 8 of our final written address. All these documents were provided to the respondent before it issued its best of judgment assessment. As such, there was no basis to go by way of best of judgment assessment. Number 2, Mr. Chairman, which we have argued, is that there are no new facts or evidence or information that the respondent has stumbled upon to warrant a best of judgment assessment. In its pleadings, in its cross appeal, as stated, in its witness statement, under cross-examination, in all the process filed before this tribunal, the respondent did not say, show, or indicate if it got any new set of facts in coming to this best of judgment assessment. As such, Mr. Chairman, our position is that the respondent has not met the conditions for issuing a valid best of judgment assessment. As such an assessment ought to be set aside in its entirety. And that is what we are arguing in our issue 1, Mr. Chairman. Mr. Chairman, our issue 2 is on whether interest and penalty can begin to accrue when an assessment is not final and conclusive. Again, we have made this argument in our final written address, specifically, this is specifically from paragraph 78. Paragraph 78 to paragraph 83 of our final written address. This is where we argued that the appellant is not liable to penalty or interest on an assessment that has not become final and conclusive, an assessment that it is challenging, an assessment that there is no basis. We have argued this in paragraph 78 to paragraph 83 of our final written address. Finally, Mr. Chairman, I will end by saying that 2 things. One, that the witness that the respondent brought before the tribunal, we've indicated this in our final written address under preliminary issues, which is from paragraph 28. Yes, sorry, Mr. Chairman, apologies. We've stated this from paragraph 34 to paragraph 42 of our final written address, where the respondent's witness kept on contradicting himself. He contradicted what he wrote in his witness statement. he contradicted himself during cross-examination. We've stated all these instances. We've quoted from the records of the tribunal where the respondent witness kept contradicting himself. And we urge this tribunal to take notice of this in its consideration of this matter. The witness, in his witness statement, which he made under oath and adopted before this tribunal, stated that the facts he is relying on relates to Zenith Bank, which is not the appellant. We've drawn the attention of the tribunal to this. Mr. Chairman, finally, that particular point is in paragraph. I just refer the chairman to that particular paragraph where the respondent referred to Zenith Bank instead of the appellant. Yes, paragraph 39 of our final written address. That is where we addressed this. He put it in paper, and that is what he relied upon. So, Mr. Chairman, our final submission is that we urge the tribunal to consider our arguments and discharge the appellant of the assessment made by the respondent, because a best of judgment assessment is not meant to be a penalty for failure to file. It's not meant to be punitive. It can only be done based on what is provided under applicable law, and those conditions have not been met. We urge this tribunal to so hold and discharge this assessment. Most grateful, Mr. Chairman and members of the tribunal. I think, Mr. Chairman, if I'm permitted to speak a bit longer, on behalf of the appellant and all of us, we want to also appreciate the industry of the tribunal accommodating us for this virtual hearing. We are very grateful, and for your guidance throughout the entire proceedings. We are very grateful. That is all for the appellant, sir.
Thank you, Pastor. Thank you also, Mr. Negotiating the hard work of it. And next is my sort of judgment. For before that, I don't know if I remember any of you like ask for any question. I can ask any question. I'm ready for option, Professor. Any questions for answer?
No question. Thank you for the copious references to
So,
thank you for copious references to the federal criminal justice services and contracts as to the I'm addressing the appellant now. As to the issue of an ascertained final and conclusive. All the times that the tax analysis and objections that the ascertained stops becoming final and conclusive. I don't know if my question is clear. Does the fact that the taxpayer has raised an objection to an assessment, does it render the assessment not being final and conclusive?
Thank you, Mr. Chairman. Once the taxpayer objects within time, if the taxpayer does not object within the time frame allowed under law, then that assessment cannot be final and conclusive.
What if the documents that the taxpayer produces response to the demands of the tax authority do not meet the expectations of the or requirements of the tax authority? Does that still make the assessment not final and conclusive?
Yeah, so, no, it won't make it final and conclusive. If the documents provided do not meet the expectations of the tax appeal tribunal, of the tax authority, what typically should happen and do happen is either the tax authority will issue a NORA refusing that objection, and then after that NORA is issued, time begins to count. A limited time frame of 30 days begin to count. So whether it's acceptable to the taxpayer or not, after 30 days, that assessment will then become final and conclusive. However, the law allows you to file an appeal within that period. So if you file an appeal within that period, then the assessment can be final and conclusive, because the whole point is the tax authority has basically passed a judgment to say, oh, you owe X amount, come and pay it. And then the taxpayer says, oh, no, I do not owe this. I have filed my returns, or I've made my payments, or these are documents that show it. So it gives that 30-day window to allow for that correspondence between the parties. But if the taxpayer ignores the tax authority, if the taxpayer fails to file his return, fails to provide documents, and that time lapses, it becomes final and conclusive. And cannot be set aside, really, except for peculiar circumstances.
Thank you. All right, thank you.
Yes.
Honorable Commissioner, sorry. Yes. About this.
Sorry, Mr. Chairman, we can't hear you. Sorry.
Hello, can you hear me now?
No, sir,
Okay,
we
that's
cannot hear
it.
you, sir.
Yeah.
Okay, you don't have much to say on this matter, but I just want to comment as carry yourself on this matter. The studying of what your regulation by other commercial. So, on that note, I think just thank you. Thank you very much.
Thank you, sir.
Thank you, Dr. Okay, so now we need to vote. Please give the appointment. We are meeting the date of 15th April. We are meeting the date of 15th April. So I look at packet table. We are meeting from 15th April. 16 potentially is already on what level? Yeah, let's visit this. 15 April. How are your calendars? Cancel? No cancel?
Mr. Chairman, whatever date you give to us, we'll take it. It's for judgment, so we'll take it, sir.
Yeah, this actually also it should be fine. You need to unmute yourself.
Okay, any date is okay, sir. Any date is okay by us, sir. But sir, will it be by virtual hearing? Mr. Chairman, sir. Mr. Chairman.
Yes.
Hello, Mr. Chairman. I said the judgment. Will it be delivered virtually, sir? Virtually, virtual dates, virtual hearing.
Well, we are going to be here, so it's not
Okay,
a point of time whether it will be virtual.
We are okay with any date, sir. We are okay with any date.
Please, if you want a virtual hearing, please, you have to send the application a week before the date, please. That's, we just got an instruction that we should assume notices for virtual hearing 1 week before the date.
Okay, thank you. Okay, noted, please.
Further to the adoption by council of the special addresses and articulation of the subjects. Judgment in this appeal is hereby reserved for Wednesday, 15th April 2026. And further proceeds the appeal plea and hereby accordingly shall be assumed.
Mr. Chairman, sir, we didn't quite hear the date.
I'll read the tribunal's review. Further to the adoption by the council of their respective addresses and articulation of their submissions. Judgment in this appeal is thereby reserved for Wednesday, 15th April 2026. Further proceedings in the appeal be and are accordingly adjourned.
As tribunal pleases. Most grateful, sir. Most grateful panel members.
Thank you. Mr. Ogoshin, you heard us. Because it's like the system is frozen. Let's ensure that it does. Mr. Ogoshin, you heard us. You are muted, Mr. Ogoshin. Unmute yourself. Let's wait for him to come back. So that does not become the impact. Or challenge. Are you calling please? John, I was asking if you have good news. Sorry to be John. Sorry to be John.
Okay, please join. Please join the meeting. Please rejoin. Please rejoin with the link. Yeah, so we are waiting for you, sir. Okay, we just want you to hear the tribunal's ruling. You can use your phone. You can join using your phone. Yes, yes. Oh, all right. All right. Thank you, sir.
So, what do we do? All right. All
Thank you.